Okay, just onto the power of attorneys. So just briefly, what is a power of attorney?
Well, a power of attorney is a document whereby a person gives to another person the right to control their assets and financial interests. So this is where I say to you, you have the power to deal with my assets and my finances. It's property only. It's not the person. So there is a distinction between a power of attorney and a guardianship document. In a guardianship document, I give to you the power to make sure to look after me, to make sure that I'm looked after, that I get medical care, that I'm I've got somewhere to live, etc., etc. I'm not that I give that to you. You're too tight. You don't need down. But the power of attorney is not about where I live or what sort of care I get. The power of attorney is about my assets and whether husbands and wives give attorney documents to one another in case one of them gets sick and is not able to deal with the assets, then the other can write the checks or deal with the bank accounts or handle all the payments and so on.
So the person with a power of attorney can go and sell the person's house.
Absolutely. So be very careful who you give a power of attorney to. Don't give it to George. You'll sell your house. And in the old days, powers of attorney were all about travel and distance. I mean, we were, in the days when we were 6 weeks travel from Europe, and people used to, everybody went on the Women's Weekly or whatever before that, and you could be away for a year or more. Obviously, powers of attorney were very important because people had to deal with their assets during that time. Now, with the invention of faxes and emails and telephones and satellites and all that stuff, those issues are nowhere near as significant. And I can, obviously do my banking literally anywhere in the world if I've got an internet connection. But where they've come into their own now, they've turned the reason for powers of attorney is turned around, and it's now used again because of the greater technology. Now because science can keep us alive for under circumstances where previously we'd have probably died, but now science can keep us alive and even fix us. But they put us into a coma for months on end, or with the advent, well not advent, but with the growth in Alzheimer's, people lose the mental capacity but are still alive for a long time. And powers of attorney are very useful, particularly enduring powers of attorney.
Okay. So if you have a power of attorney, most legal documents can be signed on behalf.
Yeah, you can't sign a will.
You can't sign a will,
but you can sign, and I'm pretty sure you can sign a binding death benefit nomination too using the power of attorney, but you can't really sign a new will.
So does the power of attorney actually stop being effective at any point in time?
Well, yes, a basic power of attorney stops being effective when you lose mental capacity. But that was in the old days. That was quite common. But as I said, with powers of attorney now being much more significant in relation to exactly that point, that's the last point that you want the thing to fail. That's in fact the point where you want it to come into place. So we've invented something called the enduring power of attorney, which is a document which says if I become mentally incapable, my attorney document still continues, my power of attorney still continues. There is legislation in New South Wales which specifically allows that and sets out the rules that apply. It has to be witnessed by a solicitor who has to give a certificate to say that you understood that was the effect of it. But it does allow for the spouse to look after the assets if their spouse becomes mentally incompetent. Of course, the other and notwithstanding anything else, the power of attorney immediately ceases on death. Right. As soon as you die, your power of attorney stops immediately, and the will takes over.
Excuse me. How do you cancel the power of attorney?
There's a document called a revocation of a power of attorney. It's a simple document. It simply says I revoke my power of attorney granted to George, dated such and such. You sign it and date it, and that's done.
making sure you find out where they've all been sent is the big problem.
Yeah, that'd be right.
Just on power of attorneys, actually, if someone's been diagnosed with dementia, should an enduring power of attorney be considered dead, or is it too late to be considered dead? Or?
Well, again, it's the same rule, George. It's all very well to say they've got dementia, but are they mentally incompetent, like 24/7, or do they have moments of clarity? If they have moments of clarity and awareness, and you can get a document signed at that point, and you can prove that at that moment they were aware and were mentally competent, then that you can get a power of attorney signed after a diagnosis of that kind.
Oh, okay. Any questions before I go on?
Excuse me, if you don't have a guardianship, can your children make that decision?
They can, and it depends on the rules of what decision that you're being made and who's going to be bound by it. Most places, of course, will listen to the requirements of the spouse and or the kids without too much trouble. But we normally have some sort of a guardianship document these days. They're relatively inexpensive, particularly as part of a total estate planning package, and it puts the thing beyond doubt.